authority to deal with that question, I must exercise that authority. But clearly, if I'm an animal control officer, or if I'm a sanitation officer working at the sludge plant outside of Bellevue, if you have one, I have no authority that brings that question before me. So although I have this duty to support the United States Constitution, it's not a duty that I can exercise through my state governmental authority. Now, if a state Secretary of State, for instance, is responsible for registering a candidate for office, and there's some way that you can look at that process and say, well, he's not simply acting in a ministerial capacity. He simply doesn't act as a clerk and take in these documents and file them and accept on the face of them whatever they say. But he has some discretionary authority to exercise, let's say, an investigatory role and determine that the representations that are made at least are presumptively true. So that, I mean, he could see some document that was filed, he could read on the face of, well, this doesn't make any sense, I'm not going to accept this, I'm going to kick this back, at least, to the candidate and make him file it again. Here we have a situation where the eligibility of this individual has become, or ineligibility, the question has become notorious. And it would seem to me that if there's any discretion within the power of that Secretary of State, or whoever he would be, the registrar, whatever office he would hold that would deal with that matter, then he would have an obligation under both the state constitution and the U.S. Constitution to take whatever steps he was authorized to take in terms of going back to that candidate, asking for more information, refusing to file the documents without some kind of supplementary clarification. Whatever it would be, he would have to do it. But it would depend, again, upon exactly what his authority is as a state officer.
Yes, and in our state constitution, I mean, we went through in our briefs and we pled virtually all of the authority that was set forth in both the Constitution, in the state statutes, and in the administrative code. And of course, the Secretary of State is the chief of elections here in the state of Washington. He is responsible to certify the primary results to the legislature. He is responsible to certify the election results to the legislature. And ultimately, he is responsible to certify the vote of the electors to the legislature. And we did a discovery request at the Supreme Court level, and the Secretary of State was totally forthcoming in the request and provided us with exactly one document upon which the Secretary relied to establish whether or not Senator Obama was constitutionally eligible. And that was the affirmation by the Democratic National Committee that he was, quote unquote, duly nominated. There was no statement as to eligibility, no statement as to his age, no statement as to his nationality, no statement as to whether he was a natural-born citizen. In the state of Washington, we have a statute that provides that any candidate for any office, with the exception of the president or vice presidential candidate who is running from a major party, every other candidate must fill out and sign and affirm on oath that they are eligible to assume the office should they be elected. Only the president and the vice presidential candidate from the two major parties, Republican and Democratic Party, are not required to fill out such a declaration. Now, I could tell you in the case that Ed knows about that we brought in the state of Alaska to overturn the primary election scheme up there.
That's a great case.
Our argument there was that there was impermissible barriers to free speech on the basis that the primary election, in fact, discriminated against nonpartisan voters. And so what you had was Alaska has a unique fact pattern in that the Democrats and the Republicans combined did not constitute a majority of the registered voters. Most voters up there were self-declared independents. And so we were able to assert that any scheme that provided for a primary election that was primarily only Democrat or Republican was discriminatory and erected impermissible barriers to free speech. And the court so held. And in this case, we have, it appears that we have pattern legislation here that provides not only a discriminatory pattern, such that the Constitution Party, the Libertarian Party, the Green Party, the Socialist Workers Party, and so forth, all of those candidates were required to sign a declaration of candidacy affirming that they were constitutionally qualified to assume the office. But when we get to the major party candidates, they have to fill out no such affirmation, and they did not fill out any affirmation, and the affirmation that came from the DNC did not even affirm constitutional eligibility. So the question, and here's my problem, I think it comes to the smell test. I mean, when the thing stinks so badly, doesn't a state officer who is the chief of elections have a duty I mean, doesn't it become so? For instance, we could sit back and say, look, there is no one here in this building that has a duty to put out a fire. But if a fire breaks out in front of the door, and that's the only doorway out of the theater, and there's 500 people trapped, doesn't a duty arise from those facts? That's my question.
Well, a moral duty certainly does, but then the question becomes as a legal duty. If I'm the private citizen sitting in the theater, and there's the bucket of sand or water or whatever it was, and the fire breaks out, and I could have reached for that bucket and perhaps put out that fire, but instead I run out the door because I'm closest to it, and 50 people die in the conflagration that occurs thereafter. Am I legally liable in any state in this country? I don't think so.
You are. I think you are, and here's why I think so. And I think you're making a great argument here, but I think ultimately we get to this crux argument that really is facing us throughout the entire world right now. And I go back to what I think is the most important precedent in the 20th century, which is the Nuremberg trials. Okay. And in the Nuremberg trials, you come up for the first time, and it's an international precedent, I believe, and it is a precedent of substantial ramifications, that when the Nazis pled in front of the Nuremberg tribunal, that at that time the argument was we have the sovereign state, there was no international community, that there was no legal authority that was superior to the sovereignty of the nations, and that under the sovereignty of the Nazi regime, they were merely following orders. But nonetheless, they were convicted, and they were convicted on the basis that there was an authority that was superior to their national sovereignty, and they got the death penalty accordingly.
But they were committed. They were charged with having conspired to and then having committed wars of aggression, war crime, genocide, crimes against humanity, whatever you want to call them, which were seen as being outside of the context of international law. I mean, for heaven's sake, even in the United States, within our own law, since at least, Fleming versus Page back in 1853, when the Supreme Court came out and said this, that our Constitution did not provide for wars of aggrandizement and aggression. So it's pretty clear that we didn't need the Nuremberg tribunal to tell us that if a Nazi party had taken over the White House and launched wars of aggression with our armed forces, and the armed forces simply went along with that even under our own law they wouldn't have been subject to prosecution. The question I'm asking, though, with the fellow in the fire, he's not a public official, he's not the owner of the theater, he's just a patron who happens to be there. And it seems to me that the law was, before I stopped going into court, the law was clear that unless there was a statute imposing on a mere member of the public some obligation of that kind, that individual could run out of the theater because he hasn't added anything to the problem, he's just refusing to participate, and he's not liable for whatever happens thereafter. Now, if he's someone who's running the theater, it's another question, even if you didn't have a statute, because he would have some kind of common law duty of care to protect the patrons of the theater, and maybe he would actually have to burn down himself attempting to save them to avoid a negligence judgment. If you're talking about a public official, the question I would ask with respect to this Secretary of State or whomever, if he's confronted with this information that's out there in the public, so that he now has a reason to believe that this individual is not qualified to run for this office, what is his recourse under state law? What could he do?
Well, I mean, I think that's a great question, and here's what, and there's two things I would say in response. One, when you're talking about the fellow in the theater, in the state of Washington, we have a statute, and it's a kind of a unique statute, but it was the statute that gave us standing in front of the Washington Supreme Court, which was RCW 29A.68.020 subparagraph 2, which allowed any registered voter within the state of Washington to challenge the election, and this is post-election, after the party was elected, to challenge the election of any person who at the time of the election was ineligible to assume the office.
Okay,
now,
good.
Bear in mind that every single candidate in Washington, with the exception of the president and the vice president, have to make a declaration of candidacy on oath saying, I'm eligible to take the office, as do presidential candidates who are non-major party members. So it strikes me that this statute has particular applicability to a presidential candidate elected by either the Republican or Democratic, from the Republican or Democratic Party. Now, with that standard being there, we have the standing. Therefore, if the fire breaks out, Joe Sixpack or whoever is sitting in the back row does have he has the statutory right and probably, therefore, the moral duty. So I want to commend my plaintiff class, first of all, for taking that bull by the horns and doing that. Now, in the second question, let me throw these facts on the table. On August 8th of 2008, I personally sent a long instruction and a long complaint to the Secretary of State's office detailing Robert Pilarik's...
Okay, hang on, guys. We got a break. Steve, are you there?
Yeah, I wanted to put one more fact on the table for Dr. Vieira's consideration.
Okay, and you're looking at... Did you get that document I sent you?
Yes, I did.
Okay.